That would be the guardian.
Good morning, and may it please the Court. Robert Latham for the Guardian Ad Litem Program. I'd like to reserve 2 minutes for rebuttal.
All right. You can talk a little louder to me.
Certainly, Your Honor. Today's motion is a motion to dismiss by the Guardian Ad Litem Program against the appeal that GCF has brought for failure to file a timely appeal. The order entered in this case was February 2nd, 2011. The notice of appeal was filed 40 days later under State of Florida v. Smith. The appeal should be dismissed for lack of jurisdiction at this time. However, the issue before the Court today is whether the Department has the right to a belated appeal under in the interest of E.H. In 1992, the First District Court of Appeal and the Florida Supreme Court was faced with the issue of a mother whose rights had been terminated.
You observe that if an order is without jurisdiction, that it can be reviewed at any time, correct?
If an order is without jurisdiction...
What is the jurisdiction of the Court to strike the case brought by the Department against the purported father?
Your Honor, jurisdiction can be reviewed at any time. The order granting the jurisdiction is a writ of habeas corpus granting jurisdiction to this Court. And this Court has an independent duty to review the jurisdiction in all cases, including in this case. The Department's position that that order is somehow unreviewable by this Court except on direct appeal creates a situation in which this Court would be unable to review its jurisdiction based on the party's conduct or consent below.
What I'm really getting at is what is going on here. Why is the guardian taking the position that the person who has acted as the father of this child and an action was brought against it is not the father of the child? What the guardian ad litem is supposedly representing the interests of the child.
Correct, Your
Honor. And I say supposedly.
Correct, Your Honor. In this particular case, so we haven't gotten to the substance of the underlying case.
Please tell me why you are doing this.
The underlying appeal involves a man who abused, abandoned, and neglected this child for years, exposed this child to domestic violence. Yes. He was facing a termination of parental rights trial, which the Guardian Ad Litem Program supported, so that the child could be adopted by the loving custodian that she's with currently. The purported biological father made his own motion to be dismissed as the father, finding that he was not the legal father, which was granted by the court. At that point, the Guardian Program saw no reason to object to that motion. And
who asked for the dismissal?
Originally, it was the Guardian Ad Litem Program, at which time we believed that to avoid appellate issues, we would withdraw that motion. The father, however, picked our motion up and went with it.
The father or the attorney for the father?
The record of the full trial, not just the hearing, states that the purported biological father instructed his attorney to do what you feel is best. That was the trial counsel.
Why are you here? Why are you appearing in this case in order to uphold that order? What is the effect of that order? It means that the original father, the allegedly legal father, who is concededly not the actual father, now must be made a party before the adoption can proceed. Is that correct?
Correct.
How is that in the best interest of the child?
What is in the best interest of this child is to have no legal relationship with the man who abused her for years and who did not comply with his case plan.
But the case has been dismissed against him.
Correct, Your Honor, and that's what we're trying to defend. The Department of Children
Why
and
are you
Families,
trying to defend that case?
We're trying to defend bringing him back, which is what the Department wants to do. They want
a determination on the merits of the TPR.
They want a determination.
And what's the problem with that?
The problem with that is because it risks losing the TPR.
It risks what?
Losing the TPR. It creates a separate appellate issue on the TPR. Right now, he is not the legal father.
That's none of your business. You want representing the child. You want the rights of this child, of this person who is acted as the father, is named as the father, acted properly. You want him out.
Right.
And that could have been done and would be done, presumably, by terminating this parental relationship without all this mumbo-jumbo, which is contrary to the interests of the child.
At this time, we don't believe it is. First off, the purported legal father does not want to be the legal father. It was his
Too
motion.
bad. Isn't that a shame?
And
You
secondly,
mean the husband, the then husband,
no,
you mean the biological
father.
Yes.
does not want to
It
be,
was his motion to be dismissed.
so you don't think there's an issue, a debatable issue, whether that motion to dismiss the TPR was made over the objection of the biological father?
There was no objection of the biological father.
Is the biological father in the picture?
He is in the picture. He has been contacted by the department. They refuse to accept his surrender at this time.
So now,
The surrender of rights?
Correct.
Is that in the record?
It's not on the record. It is in the record in the full appeal, not on
he
the
has
hearing.
surrendered his rights.
He has set to surrender his rights.
But he can't because he has no legal standing, right? He is not a parent under the statute, so he has no rights to surrender.
Without getting too deep into the underlying appeal, he is the legal father under the statute. He is the man who was married to the mother at the time of the child's birth and conception.
Oh, okay, so the ex-husband.
The
We're talking about the
ex-husband.
ex-husband.
Right. He wants to surrender. The department will not accept it. The department has
Because of this pending case.
Because the department has forced us into this position now. They won't accept his surrender. They want to bring back the
They won't
other
accept true surrender. The husband
The husband's surrender, yes.
is now an
Yeah,
ex-husband.
let's call him the husband.
The husband. He is now an ex-husband, is he?
He is now an ex-husband.
And he has not been, well, he's not been terminated because he'd be happy to be terminated.
It's not up to the department to accept the surrender or not. It's up to the court.
Unfortunately-
It's up to the court either to terminate the parental rights of the actual father, who was the named party in the case, or to accept the surrender of the rights of the purported father, who was the husband and who's not the biological father. It's not up to you. Are fighting over something which both of you want the same thing, and you are dragging this child through these proceedings ridiculously. There's something, we should grant a writ of ridiculousness and cross this entire proceeding.
If we were to reach the merits of this issue, the issue is whether or not the putative biological father has standing. Correct? That's essentially the issue. Whether a petition can go forward against him, which calls into question whether under the statute he has legal standing. Right?
That is the issue.
If we were to rule on that issue on the merits in your favor, that would end it for him, would it not? That would be a determination that he has no rights, no standing, therefore no TPR can proceed.
Right. And that would be the issue for the underlying appeal, which hasn't been briefed in
But
this.
wouldn't that give you the finality that you say you want?
It would.
So then why are you moving to dismiss the belated appeal,
The
other than on procedural grounds?
The belated appeal is the department's attempt to bring, we'll call him the biological father back into the proceedings
Right.
and proceed with the termination.
They want to say the court erred in dismissing the petition on the basis that he had no legal standing.
So that it can terminate his rights.
But under the law currently, he has no rights to terminate. And if the court...
But that would be if he has no rights to
That would be a decision for the court.
And if you're that confident about it, why not let it go to the merits and let us decide whether, in fact, you are correct and the biological father, putative, has no legal rights? Why not let us decide that? Why are you all...
In actuality, nobody has a dog in this appellate fight. Nobody.
Right, because the biological father
We
didn't
could
move
dismiss
to
all of these proceedings on the ground that there was no moot.
And I wouldn't disagree with that.
Oh.
That would be fine with us.
No,
Because it leaves the underlying issue. The father has been dismissed, and we can accept the surrender.
You are not seeking to uphold or maintain or preserve whatever rights this biological father may have in a subsequent adoption.
Absolutely not. Our goal is to achieve permanency for the child as quickly as possible. Going through a termination of parental rights
And
trial.
that's the same as what the department.
And that is supposedly what the department is doing.
Well, the department in this case is seeking an appellate opinion on
It's
paternity.
because they want everything to be pure.
Well,
They don't
this
want
is-
somebody in the future to challenge this. Nobody is challenging it. This is not This is not a case or controversy.
Right, Your Honor, and you're absolutely right.
I thought that that there was a limitation in the financial resources assigned to both the guardian ad litem and to the department.
Your Honor,
is that true?
Of course, Your Honor.
And we have 4 lawyers here. We've had papers like this for absolutely no reason.
How about if I give you a minute for rebuttal? Thank you.
Hey, please, the court, Carla Perkins on behalf of the department. Actually, the attack care judge is on the adoption of the child, and there is case law that says that when the biological father, in this case M.I., who's been treated as the father from 2007 in the case, there is B.B. versus JPM that is on point about him having the right to contest the adoption of the child.
Well, but he can't win, so he cannot win. Neither party can win. Neither one who was supposedly against the adoption is not against the adoption. Either the actual father has been terribly abusive and his rights will be terminated, and the ex-husband wants to relinquish his rights.
Judge, the former husband said he disavowed any parental rights to the child.
Yes.
He is saying I'm not the father. He was in Italy when the child was conceived and born in Florida.
Yes.
And we have case law on that says that's the non-active rule, that he can't even be deemed the father.
Also, don't you understand what is going on here? You're arguing about the angels on the head of a pin when everybody wants this child to be adopted, including both fathers. Neither one of them either has no rights or is wanting to surrender the rights. Instead,
Judge, I have to correct about both fathers because the biological father M.I. stated all along that he wants his child.
But he can't win.
And you want to terminate.
You want to terminate his rights.
We do, but we're not. I mean, the trial has not concluded that we have won. We have not won.
You know, it's none of his business either. He has now been determined to have no rights on the child whatsoever.
Let me ask you a question. The child will be
adopted without him.
Can I ask you a procedural question? You concede, of course, that M.I. himself has not filed this appeal. Correct?
He's not filed a belated appeal.
He is not a party to this appeal at all.
He is a party to the appeal. Yes.
He has not filed. He's not seeking relief from this court, from the trial court's order determining that he has no legal standing in the CPR.
No.
He is not seeking affirmative relief from this court.
He did not file that, but we filed it because we're the guardian of the
Because
child.
you're worried about something happening bad when nobody else is worried about it.
Judge, what I'm trying to tell you is he can attack the adoption of the child. If we just have him disappear into Neverland, I'm telling you that there's case law that says he can attack the adoption of the child.
What I am telling you, and I think your choice of verbiage is very ill-advised. What I am telling you is that we are a court of justice, believe it or not.
Yes, Judge.
And you don't have to tell us what the law is. We make the law. You understand?
I understand, Judge, but there's a case.
But you don't understand.
I do.
Ms. Perkins, doesn't in the adoption process, does not this biological father have some preference during the course of the adoption process itself?
Absolutely. There is case law that says in the adoption
he may not be the legal father under the law. The legal father under the law may be the ex-husband, right?
Judge,
because this child was born while the mother was married, correct?
The child was born while the mother was married.
And so from a legal standpoint, arguably, and perhaps true, this father has no legal rights to be the father, because if the child is born during the course of a marriage, even if the biological father is outside the marriage, it's the child of the mother and father, correct? Am I right on that?
Well, you're correct in the sense where the law says that's the presumption, but it's a rebuttable presumption. And the husband has come in, the former husband has come in and rebutted that presumption The law has separated paternity from legitimacy.
What happens if we dismiss, this appeal is untimely. There is absolutely no question that it's untimely. You cannot, the trial court cannot extend the time for filing a notice of appeal on the grounds of incompetence of counsel. Only the appellate court can do that. This order is a complete nullity, and this appeal is untimely and should be dismissed. The only question is, why are we going through all this?
Judge E.H. out of the Supreme Court says that it's the trial court that grants the petition for habeas corpus. We filed the petition for habeas corpus in the trial court, and the trial court granted the right for belated appeal.
The reason the habeas corpus was granted is on the ground of the fact that the notice of appeal was untimely filed due to incompetence of counsel. That is an appellate habeas corpus which has to be filed with us. The trial court cannot extend the time for appealing from its own order. So it's and if there were otherwise, the reason that the ground asserted for incompetence was that you forgot that the time is running is ludicrous.
Judge, I would have to disagree where in Ray E.H. out of the Supreme Court from 1992 says the proper vehicle to obtain a belated appeal in a termination parental rights case is for the petition for
where child custody is being determined. Where child custody is being determined.
Well,
there was a determination on the merits terminating the parental rights in E.H., correct?
Correct.
Here there was a dismissal of a petition for the termination of parental rights, and you all are seeking to appeal that and are trying to get around the bar because you did not file it timely because somebody missed the deadline thinking perhaps the motion for rehearing was solid, and so now you're raising the issue, well, we are the parents and we have custody of the child, so this should come in the form of a habeas corpus.
Judge.
So you want us to extend E.H. to a case in which there has been no determination on the merits, but rather there's been a dismissal of the TPR. Are you not asking us to extend E.H. to this circumstance?
We're asking you to recognize that the department is a legal guardian, and if you go by the Florida statute that determines legal custody, it tells you that legal custody.
How do you have a right to appeal on any basis after the appellate time has run?
That's why we sought the belated. That's why we filed the petition.
You brought a belated appeal.
We brought the petition for belated appeal.
The habeas corpus.
What, as a practical matter, counsel, were you seeking to accomplish prior to the dismissal of the TPR? On the biological father. What is a practical matter?
The problem that we have here is the biological father's name is on the child's birth certificate. He supported the child before he was deported to the Sudan. The department filed through every single proceeding.
And is there evidence, or the department would have evidence that the father was abusive with the child, the biological father?
We filed a TPR petition based on abandonment, really, because from the time he was deported to the Sudan, he failed to communicate with the child, and he was paying child support, he was doing whatever else.
He was paying, is there any, I know we're getting beyond the issue here, but is there evidence that you would present that the father was abusive, the biological father?
The case ever came in about DV between the mother and the father.
And then between what? I didn't hear you.
Domestic violence between the mother and the father.
Mother and the
biological.
Mother and the biological father.
Right.
Okay. So what is it that you seek to accomplish? What is it that you were seeking to accomplish as a result by the petition?
If this court reviews the December 15th transcript, what you will see in there is before the father in the Sudan.
What are you seeking to accomplish?
We want to complete the TPR trial.
And the reason for that is, okay, go ahead. Now you.
Because he can't attack it later on in an adoption proceeding.
Absolutely.
But if he attacks it later on in he cannot attack it later on. He has moved to dismiss it and he has won. He cannot do it.
Can I put in a correction? This is why I was referring to the December 15 transcript, because I'd like to correct something that was put before this court a while ago. In the December 15 transcript, what you will see, and if you look at the prior transcripts before, because it's all
Tell us a little.
The biological father has always said he wants a child. His attorney, before the father was on the phone, the father was not on the phone from the Sudan when his attorney entertained that conversation with the court about dismissing the case. He was not.
So what?
Did he obtain new counsel and file an appeal?
Judge?
Yes or no?
Yes or no?
We were trying to get him
Yes
new counsel.
or no?
He just got new counsel when we did the motion for the latest appeal.
Think about the unintended consequences if we extend EH to a situation in which the court does not reach the merits of the TPR but dismisses it on the basis of lack of standing. You are asking us to say that the law now is that DCF has the right to raise its own ineffectiveness of its own attorneys and file a belated appeal from an order which never reaches the merits of the TPR. This could extend to every single case throughout DCF in which the court never even reaches the merits, but dismisses it. You're going to be able to file belated appeals anytime on the theory that somehow later on in a subsequent proceeding, it may be attacked by the biological
If
father.
it's attacked, counsel, if we dismiss this appeal, which is, I wouldn't be surprised if that happened. If we dismiss the appeal, you are going to go ahead and try to get this child adopted, are you not? Are you not?
Yes, sir.
And if the father, either father, comes in and objects to or doesn't give consent, you are going to say either you have no standing, as the court has agreed, if this court has agreed in this order, which you secured and from which you did not appeal, and you are going to win. Or, and if you lose, then you have another remedy. But this is not it.
Judge, if I could just respectfully point out the fact that the multitude of case law out there gives the biological father
Counsel, all you have to
The trial court has said that the trial court has dismissed the petition on the ground that this biological father has no legal right, no standing to bring any sort of action, right?
Correct.
So you have the order that you want.
The problem
You have the order that you want. You have the order on the merits.
We understand the reason why you want to dot all the I's and cross all the T's. And had you filed the appeal timely, we would be reaching the merits of the standing of the biological father.
Maybe
but you all did not.
Maybe not.
And you're asking us to make an extraordinary statement that the writ of habeas corpus is available to DCF because they are the child's custodian.
But Judge,
and that therefore the ineffectiveness of your own counsel can serve as the basis for a belated appeal and to extend the age to that holding.
Do you understand that habeas corpus to seek relief from an untimely notice of appeal caused by ineffectiveness of counsel is a recognized use of habeas corpus? It applies in criminal cases. It does not apply only to domestic cases or family law cases. It applies to all cases. A habeas corpus is just a way of saying it. You have to go to the appellate court. It's a habeas corpus in the appellate court seeking appellate relief.
If you want to wrap up, Ms. Perkins, go right ahead. If you want to wrap up.
the Florida Supreme Court has said that the proper vehicle to file for relief to obtain a belated appeal is to file a petition for writ of habeas in the trial court. That is what the Florida Supreme Court has said. So that's what we followed. They said we had to file it in the trial court. The fact here is And as I said before, if you look at the December 15 transcript, you're going to see that the biological father did not move to dismiss.
And so you're asking
His
us
attorney, without him being present, did that.
I didn't mean to interrupt you. So you're asking us to deny the motion to dismiss and to address the issue on the merits? Yes?
Absolutely, Judge.
Thank you. Thank you
And we
very
would
much.
ask for anything, if you're going to relieve us and grant our relief, we would ask for an expedited schedule on the whole briefing thing because, you know, the mother's appeal is basically just about over.
Oh, very good. Thank you very much. Yes, if you'd like a minute for rebuttal.
Hey, Mr. Court, I just wanted to let you know that Eileen Hersher, on behalf of the biological father, MI, and that I would agree that MI is not seeking affirmative relief from the third DCF.
And you're saying that on behalf of the biological father?
Yes, I am.
Thank you very much. All right. Thank you all.